Very much, Mr. President. As I have sat here over the past 2 days, Mr. President, and in particular, as I have listened to the members of the independent bench of this Senate, I found myself reflecting on the wisdom of the Roman times and the concept of the Senate, which involves an assembly of wise men and women. And I want to say thank you to the independent senators for the contributions which they have made, every one of them. Senator Vera, Senator Thompson-Ahi, Senator Maraj, Senator Dylan Remy, Senator Timal. Because we have had, on a very important piece of legislation, bill that we ask to pass into its maturity as legislation. We have had very balanced, thoughtful, wise commentary, all of which I take on board as Attorney General and advisor to the government. As we go forward with this legislation, I expect that much of what the independent senators have contributed will inform very materially, in particular, the regulations which are to be built out under Section 28, Clause 28 of the bill before this House. So I thank the independent senators for their contributions. I'm not going to belabor the point. We have had erudite submissions, and I think they have been very clear, pellucid, and at the risk of seeming to do a disservice to them, I will not spend an undue time. I also wish to thank the members on the government side, Senators Cox, Hislop, Lizam, Leasing, London, for equally their very mature reflections on this very important piece of legislation. Bill. I've listened to the opposition senators, and as I have tended to do so often in my time in this hallowed place, I regret the fact that as wise as the Roman senators were, there are exceptions to every rule. I acknowledge the comments of Senator Bisram Singh because I accept that while at the end of the day she delivered certain criticisms of the bill, there was an encouraging, reflective contribution from her, which I also intend to take under full consideration. What? That, of course, being the single exception with respect to the opposition bench. Mr. President, I've reflected on a lot of the discussion that has taken place on the need for a simple as opposed to a special majority for this bill. And I just want to share with the Senate, this August chamber, a couple remarks from my experience as a constitutional lawyer. The concept of constitution is something which we inherited from our colonial masters, the United Kingdom. They have an unwritten constitution. And the jurists and the parliamentarians who promote, apply, and regulate the application of that constitution, through their maturity and their wisdom, have respected the fact that a constitution is a very different instrument, whether unwritten or written, because what it does is it regulates the lives of citizens for the present with a good, candid look on the past and into the future. It is impossible to write on a piece of instrument or to lay down unwritten codes that in that context as a constitution which looks to the future can ever be static. It must be an evolutionary guideline by which societies regulate themselves. That is the essence of a constitution. It is what makes a constitution different from ordinary legislation, which seeks to deal with a particular matter at a particular point in time. So the English, when they came, the British judges of the Privy Council, and we can go back in my student days, and those of us who are lawyers, Senator Vieira will recall the case of Fisher and the Minister of Home Affairs out of Bermuda. It was a constitutional question involving a case involving a child, and in relation to the written constitution of Bermuda. The Privy Council developed in articulate terms, perhaps or not for the first time, the expression, the living instrument. And that was a term that the English jurists, out of their experience of an unwritten constitution, which is an evolutionary thesis of order in our lives, applied the concept of the living instrument to that unique instrument that we have inherited out of Westminster, the written constitution. And what Fisher laid down was a principle of construction that when you come to look at a written constitution, you have to respect the ethos and the origin of constitutional government, because that constitution must always have the capacity to speak of the present, to have its roots in the past, but to look to the future. In other words, it must live. And it must live by being in touch with the society under whose rules the society is to be governed. It cannot hold the society prison in one point in time, because the society has to grow, it has to live, it has to change with its evolution and its time. And that concept of the living instrument continues to this day, Mr. President, to be applied as what is known as the purposive rule of construction that is applied by all judges to our written constitutions in the Caribbean. In this case, the written constitution of the proud Republic of Trinidad and Tobago.
Brilliant.
We have, Mr. President, under Section 53 of our Constitution, the mandate that the government, the Parliament, is to pass laws for the peace, order, and good government of the citizens of this country. And the Parliament, by the Constitution, is the preeminent legislative authority under our written Constitution, applying the purposive construction, which is charged always maturely out of balanced discussions, such as we've had from the independent bench in particular and from the government side over the last 2 days, to assess a particular situation at hand. In this case, crime, the fear of reprisal, the retaliatory impact of criminals and potential criminals who will not allow whistleblowers to reveal the sully that lies beneath the surface and hides from daylight. So the Parliament, in passing laws for the peace, order, and good government of this country, has to apply the concept to the constitutional discharge of their functions, that they are making laws as part of a living instrument for the future. And that is where we came to the Suraj decision. And I commend that Suraj decision, and I'm very proud of it because I actually happen to represent the Attorney General in the High Court and in the Court of Appeal It went to the Privy Council. I was not part of that team, but I understand how that case developed. And I commend it as necessary reading for all of us in this Parliament, and even for some of the lawyers who purport to speak law. I would recommend it, in point of fact, for Senator Tim Gopi Singh. I would not dare, and I have no doubt he would criticize me, if I purported to give him a lecture on obstetrics and gynecology, as he purports so often to give us lectures on the law. So I commend to Senator Gopi Singh that he should sit down and read Suraj, or Senator Mark, or Senator Lachmidial, who dismisses that judgment. The textbooks are going to write about that judgment. The constitutional law textbooks are going to write about that judgment for the next 100 years. Mark my words. And it's come from the courts of Trinidad and Tobago, and the Privy Council in that decision was affirming dictum of the Court of Appeal of this country, our judges. And Mr. President, when we come to Suraj and we ask ourselves the question, how do we approach passing the law that is the Whistleblower Bill? And do we need a simple majority or a special majority? How do we apply this 2022 judgment that was delivered in June of 2022, 8 years after the first iteration of this bill went into Joint Select Committee? I will read, with your leave, Mr. President, only 3 passages of the judgment of Suraj, if I may. Only 3 passages, Mr. President. Paragraph 67. Section 1(1) of the Constitution declares that Trinidad and Tobago is a sovereign democratic state. Accordingly, Parliament is established as the body with authority to make laws for the peace, order, and good government of the country. Section 53. As the majority judgment correctly pointed out in Francis being this Court of Appeal, Mr. President, interpreting the rights in Section 4 as subject to an implied proportionality qualification means the effect can be given to Section 53 in circumstances in which a supermajority in each House is not always attainable. Paragraph 68. A very large part of ordinary legislation passed by Parliament for good reasons of the public interest. And what is the public interest that we are concerned with here? If I may just digress for a moment. We are concerned with the public interest of passing laws for the peace, order, and good government of this country to safeguard the citizens of this country from the scourge of crime, to regulate a process by which persons who apprehend that crimes are about to be committed or acts or misdeeds are about to be committed can feel confident to make a report of that fact and to be protected from retaliation. So if I continue with Suraj. A very large part of ordinary legislation passed by Parliament for good reasons of the public interest must inevitably interfere with or operate as restrictions on those rights. In the board's view, it is not plausible to suppose, and here we are talking about the living instrument, it is not plausible to suppose that the framers of the 1962 Constitution and the current Constitution intended to disable Parliament from taking ordinary legislative action in the public interest. The natural solution to accommodate the inevitable friction which always exists between fundamental human rights and democratic decision-making in a constitutional, liberal democracy like Trinidad and Tobago is that conventionally adopted so often in such states, namely, to require that interference with such rights should be permitted in the public interest, but only if the interference is proportionate to a legitimate aim. And if I may read one further paragraph out of Suraj, Mr. President, with your leave. Paragraph 81. Since the rights in Section 4 have to be read as limited or qualified rights, not absolute rights, as explained above, and acknowledged in the Thornhill case, another Trinidad and Tobago Court of Appeal decision. Thornhill. I studied it when I was at law school in the 1980s. They have to be capable of carrying the relevant qualification with them as they develop according to the living instrument doctrine. The nature of the Constitution as a living instrument therefore indicates that a more general form of qualification must have been intended and points to the proportionality qualification set out in Surat, another Trinidad and Tobago case. Furthermore, the fact that the rights are liable to change in ways which have new and wider effects on government activity, which itself adapts as society develops. We're talking here about the living instrument, which itself adapts as society develops, means that the scope for friction between the fundamental rights of individuals and the general interests of the community, referred to in paragraph 68 above, is likely to increase, which still gives greater force to the point made there. This reinforces the inference that it must have been intended that the rights in Section 4 being the fundamental rights provision, should incorporate a mechanism to strike a fair balance between those rights and the public interest. The proportionality qualification identified in Surat is the appropriate mechanism for that purpose. The short point there being, Mr. President, that when we come to look at the bill before us today, we ask ourselves the question, what is the legitimate aim? The legitimate aim is to provide a regulatory framework to protect whistleblowers who can unearth criminal or other activity that is inimical to the fabric of this society, crime, corruption. And that being the legitimate aim that the bill is intended to achieve, you have to look to see what are the mechanisms within that bill that strike the appropriate balance so that rights which are impacted, fundamental rights to privacy, and Senator Vera made the point that the fundamental right to privacy, yes, it is impacted, but it has to be balanced against the fact that that right to privacy must back away from the greater interest of allowing persons to disclose misdeeds and therefore cannot trump the right of the whistleblower to give his story. And there is case law that makes it clear that in this case, the right to private life, which is guaranteed under our Constitution, that is what is guaranteed under our Constitution. The right to private life cannot be used to trump an institution which is operating corruptly, and that institution saying, I as an institution am entitled to privacy and therefore my rights have been impacted by the whistleblower spilling the beans on me. So you have to look at the facts as they develop, and you have to apply the Constitution as a living instrument. And that, Mr. President, is the reason why, with the passage and the delivery of the judgment in Suraj in June of 2022, the language of the three bills that started in 2015 and had their second iteration in 2016, in 2018, and come here in 2024 as a 2022 bill, did not have to be rewritten fundamentally because the law had moved on as a living instrument. So the suggestions that come from those who regard themselves as learned lawyers, that because the bills were drafted in 2016 and there has been no substantial modification, Suraj cannot apply, is to fail to understand the law.
Oh, what an indictment.
May I say, in answer to criticisms which have been made of me, that as the client, I take advice. And I respect the right of lawyers who give me advice as a client to the client-lawyer confidentiality. And that is why I am not about to share any opinions that I get from eminent silk for them to be bandied about and made little of. But I will say this because I asked his permission. I asked the external silk whether I was allowed, because I wasn't going to put his name into the public domain for some of us here to hang his name from the rooftops, doing a disservice for him. One of our most eminent constitutional lawyers who provided the external opinion with which Chief Parliamentary Counsel Mr. McIntyre agreed and then proposed Section 28 is Mr. Douglas Mendez, who has lectured some of us in this chamber and has lectured for 20 years on constitutional law and is Trinidad and Tobago's, perhaps Trinidad and Tobago's foremost constitutional lawyer. I say no more. And I'm not sharing his opinion. Mr. President, I will say a few more words only. This piece of legislation, this bill, is a work in progress. It has been on the books since 2015. It returned in 2016. It returned in 2018. It returned in 2022, and we are debating it now. It is time we make it law.
Absolutely.
I acknowledge that it is a work in progress. We have regulations to build out, and Section 28, subsection 2, gives the commitment, once this bill becomes law, that we will come back to this honorable chamber for consultation on the regulations we are going to build out. And a significant percentage of the contributions which have been made in this chamber and in the other place will be taken into consideration in the drafting of the regulations to give flesh and bones to the protection and the sanctity that the whistleblowers are entitled to. So, Mr. President, without spending too much more time unduly, I ask this honorable chamber to embrace with both arms the opportunity to put this bill on the statute books. Let us make it law. No piece of legislation will ever be perfect. As our society evolves and as we apply the living instrument doctrine, we will improve it and we will bring it back here if necessary for amendment. But let us pass this bill into law. And with those few words, Mr. President, I beg to move.